Good afternoon, ladies and gentlemen. My name is Chris Wilson, Communications Director here at the Dallas-Fort Worth Hospital Council. Normally, my President and CEO, Steve Love, will be providing the intro. He's at a Chamber of Commerce meeting today, moderating a panel discussion, and it was postponed an hour. So he sends his apologies, and we're just going to go on with the show. Today, this educational webinar is hosted in coordination with Hall Render, a longtime associate member of the council. Today's topic is navigating the minefields of healthcare immigration, physicians, and RNs. We have been looking forward to this presentation, especially with Michael Kim. He's a national expert on this subject, and he's spoken at events for the council in the past. With the healthcare workforce shortage across the country, recruiting physicians and nurses from outside the country has never been more relevant. Today, Mr. Kim will discuss physician-related immigration, J-1 waivers, H-1B petitions, and permanent residency processing. As noted earlier, our speaker today is longtime Hall Render attorney Michael Lee Kim. He leads the firm's immigration practice and focuses almost entirely on business immigration matters. And I have some other bio info here, but I'm going to go ahead and pass that up. I think Michael has that information as well. But we are looking forward to his presentation. A final note, should you have questions, please feel free to type them into the question box or the chat box, and we will relay those to Michael. Also, he wants this to be more interactive today. And so if you would have a question for him and take advantage of this, this is a good opportunity to speak live with a national expert. Just raise your hand. There's a place there where you can raise your hand, and I will unmute you and you can speak with him. Also, if you want to just put a question in the chat box or the Q&A box, I will unmute you as well, and you can ask him a question. He would like this to be as interactive as possible. So let's get started. And with that, ladies and gentlemen, here's Michael Kim.
Chris, thanks so much for the introduction, and thank you all for the opportunity to engage in this conversation with you. Just to add on to what Chris said, each of you has a unique and valuable perspective on the immigration process, and to the extent that you feel comfortable in sharing any questions or concerns or observations that you've had as you've been involved in the immigration process, I think we would all benefit from having you share that. So Chris has already gone over the agenda, and I'll just add a little bit of background to myself. I have been practicing healthcare immigration for the last 22 years, focusing on physicians primarily, but also other allied healthcare professionals. So if it's happened and it's immigration related in the healthcare space, then we've probably seen it, taken care of it, handled it. And this subject matter is really near and dear to my heart. Both my parents were physicians and they were immigrants, so they went through some of the processes that we'll be talking about today. So without further ado, what I'd like to do is talk about the recruitment process from its earliest possible stages. And what I mean by that is individuals who are in medical residency or fellowship training. And I wanted to, just as a kind of a primer, talk about, well, why are we here and why are we talking about this subject matter? And these next two slides, I think, really kind of answer that question. Now, this data is a little bit old, but as you can see, since 1981 up to 2021, the percentage of practicing physicians in the United States who are foreign-born, foreign-educated, and required some form of sponsorship has gone from 9% to 26%. That's pretty huge. And it's estimated there are around 325,000 foreign medical graduates who are practicing here in the United States. And we probably are feeling this, seeing this as employers as well as consumers of medical services. And we're noticing that foreign physicians are filling some significant and much needed gaps in areas of poverty, ethnic neighborhoods, and areas where the educational level is fairly low. We also know that there is a shortage. There's a bona fide shortage of physicians in the U.S., and we're anticipating that by 2036, that shortage may reach 86,000. And I've candidly, I've seen figures as high as 130,000. So I don't think that's unreasonable. We also know that U.S. medical schools are not churning out enough medical graduates to backfill this talent gap. And we have an aging population, and I think this statistic or this fact is really fascinating. 1 in 3 actively practicing physicians in the U.S. is going to reach the age of 65 or older in the next decade. So hypothetically, in about 10 years, a third of the physician workforce is going to be exiting the workforce, and that's going to further exacerbate our shortage. So again, talking about starting the recruitment process as early as possible, we're talking about medical residents and fellows. And if you are a foreign medical graduate and you are training in the U.S. in J1 status, then you are automatically subject to the 2-year home residency requirement, also known as 212E. So what does that mean? The J1 visa classification is an exchange visitor visa. And the intention is for the individual to come over to the United States, engage in training, education, etc., and then go back to their home country for a period of 2 years and kind of give back that knowledge, training, experience to their home country. And there are a number of prohibitions that 212E places on a J1 medical resident. You can't change your status from J1 to really any other non-immigrant status except for A and G. And A and G are reserved for ambassadors and diplomats. And in my experience, I've run into that one time. So that's a very rare occurrence. You can't apply for an H-1B visa stamp, a travel document at the U.S. Embassy or U.S. Consulate to try and enter the U.S. as an H-1B, and you can't apply to adjust your status to permanent residency. So, as you can imagine, if you spend 3, 4, 5, 6 years in the United States training, and you're developing networks and friendships and communities, you probably don't want to have that interrupted artificially for a 2-year period because you've got to go back home. So the only way to get around the 2-year home residency requirement is to obtain a waiver. So there are many different kinds of waivers. The two biggest groupings are employment-based and then individual-based. And we're not going to be talking about the individual-based because those are fairly rare. It's going to be fairly rare for your candidates to be in that situation. So we're going to focus on the employment-based. And probably the most well-known employment-based waiver is the Conrad 30 waiver. Now, it's so named after Senator Kent Conrad, and the 30 represents the number of spots that are available each year in each state that participates in the Conrad 30 program. And just so you know, every state in the United States does have a Conrad 30 program. So that's 30 times 50, 1,500 Conrad 30 spots that are made available each year. Now, the deal with Conrad 30 program and other waivers is that it allows the J1 to avoid having to fulfill the 2-year home residency requirement. Both specialists and primary care applicants can apply under Conrad 30 programs. And one of the requirements is that, and we'll get to this, but the physician must complete their waiver obligation in exclusively H-1B status. You should also know that some programs do charge a processing fee, and some of them are quite exorbitant. If you take a look, Texas charges $3,000. So that's pretty high. To give you some context, the state of Indiana, where my office is based, they don't charge a processing fee at all. So just be advised as you kind of navigate into the waiver process, there may be some charges in order to get an application reviewed. So again, the J1 waiver is it's kind of a quid pro quo in exchange for the physician working in a medically underserved area or a health professional shortage area for a period of 3 years, working full-time, 40 hours a week, providing direct patient care. They can have the 2-year home residency requirement waived. And it's important to understand that the waiver application, what are you waiving? You're waiving the 2-year home residency requirement. So getting waiver approval does not mean that you have work authorization, and it doesn't mean that you have permission to remain in the United States. And in fact, because of the timing and when the waiver application is submitted, the individual is still going to be in J1 status, completing their residency or their fellowship. But what the waiver approval will do is it'll allow them to change their status eventually to H1B. Now, this slide shows kind of the common elements of all Conrad 30 programs across the country. And you should know that every state is required to meet at least the federal requirements for the Conrad 30 program, but then each state has the discretionary authority to kind of administer the program as they see fit. So they can add more requirements, they can change up the application period, et cetera. They can only entertain primary care if they want, things of that nature. But these are the common elements, and across the board, the physician is going to have to work in a medically underserved area or a health professional shortage area. And all J1 waiver physicians have to agree to commence employment within 90 days of USCIS approval of their J1 waiver application. And finally, every state has the discretion to set aside 10 of their 30 spots for what we call flex waivers. And a flex waiver is where a physician is placed in a location that is not designated as a HPSA or MUA. And every state kind of handles this differently, but the gist of it is this. They will allow that placement of the physician in a location that is not designated if you can show that the patients that will actually be seen at the worksite location actually reside in a nearby HPSA or an MUA. Different states will have different threshold requirements. So for example, the state of Indiana, when it did entertain flexes, they don't do that anymore, but when they did, they required that the petitioner sponsor show that at least 50% of the patients seen at the facility where they were going to place the J1 waiver doc actually resided in a nearby HPSA or MUA. And that's a pretty high threshold to prove. Other states might have it as low as 30%, and some don't use the 30% threshold at all. So another kind of waiver, and this segues very nicely with the Conrad 30 program, is the HHS waiver. The HHS waiver is reserved for primary care candidates and hospitalists only. And the reason why this is kind of complementary to the Conrad 30 program is this. Over the years, even though the intention of the Conrad 30 program was to help communities get primary care physicians to help serve their patient population, the reality is over the years, employers within the states, well, they're not leveraging the Conrad 30 program for primary care candidates. And in fact, they need to use the Conrad 30 program for specialists. And so what we would see in terms of the data is that 50% or greater of the applications that are being submitted across the country, generally speaking, are for specialists. But some holdout states, like the state of Indiana, took the position that, hey, they're still going to prioritize primary care candidates. And even if, say, you're a first come, first served operation, if a specialist submitted their application first, but then 30 primary care applicants submitted their applications afterwards, that specialist would get booted out and they wouldn't get a waiver that year. So HHS serves as a nice kind of a relief valve for the Conrad 30 program. And the threshold requirements for an HHS waiver are fairly low. So the worksite location does have to be a HPSA designated location, but the score only has to be a 7 or above. And the biggest benefit of the HHS is that there's no numerical limit. They don't only have 30 spots per state per year. HHS can approve as many waivers as they see fit throughout the year. So the application period is rolling. There is no specific application period for HHS waivers, and they can approve as many as they'd like. So probably the most critical, well, one of the most critical and important pieces of a waiver application is the employment agreement. And this is where we field a lot of questions on the front end when an employer is recruiting a J1 candidate, J1 waiver candidate. So many states, many programs have specific restrictions and prohibitions on the type of language that can appear in the employment agreement. And as well, there is some language that they require be inserted into an employment agreement. And this typically will go against your normal practice with your U.S. physicians or green card holders because they don't have those requirements. But understand that in the state of Texas and HHS can't have non-competes, can't have restrictive covenants. The state of Texas will entertain some non-solicitation provisions, but that's going to be on a case-by-case basis. Most states, and including the HHS waiver program, will require you to have language in the agreement that says this agreement can be terminated for cause only, which means you cannot have a mutual termination clause. You cannot have termination by notice. So again, this is fairly different from your normal practice. And you're going to be treating your J1 waiver candidates differently than your US candidates. And that's something that you should understand and feel comfortable with from the outset. So some practical advice with J1 waivers. Don't wait until the last minute. And you really ought to be talking to candidates, and candidates should be seeking you out, candidly, at the beginning of their last year of training. They should be having those conversations, and you should be nailing down the employment agreement language and getting it signed so that you can get your waiver application in as early as possible. So with state programs, and I'm going to use Texas as an example, which is super competitive, the application period opens September 1 every year, unless it falls on a Sunday or a Saturday. And their application period is only open for 14 days. So if you don't get your application in on time, then you're out of luck. And even if you do get it in on time, understand that it's quite competitive and they will always receive more than 30 applications. So it makes sense, again, practical advice, if you are recruiting for physicians and you know that you will entertain J1 waiver candidates, probably behooves you to put that in your advertising and let it be known up front that you will entertain a J1 waiver. But before you do that, make sure that the worksite location that you intend to place the physician is designated as a HIPSA or MUA. You will not be necessarily innovators because, like I said, and we do this all over the country, many employers are taking advantage of the J1 waiver programs to kind of backfill their talent gaps. So you might not be in intrepid spirits, but you will be joining a tidal wave of compatriots that are doing the same thing. So in terms of competition, understanding that your competitors are doing this, it behooves you to be familiar with the process and to have some comfort level in the questions and concerns raised by candidates as they go through the interview process. From a timing perspective, I just wanted to mention that you can expect the J1 waiver process to take about 4 to 6 months. And another critical issue with the J1 waiver program that really shouldn't be overlooked is you're turning to the J1 waiver program as an option of last resort, which means that as a part of your waiver application package, you have to be able to provide evidence that you unsuccessfully recruited for a U.S. physician. And only because you were unsuccessful in recruiting a U.S. physician are you turning to the J1 waiver program. And that recruitment evidence, depending on the state, depending on the program, needs to be during the 4, 6, or 12 months immediately preceding the filing of the application. So for Texas, if the application period opens September 1, well, you need to be looking back for 6 months so that you can provide that evidence. So as I mentioned, J1 waivers is quid pro quo. And once the J1 waiver is approved, then what that does is it opens the door for the employer to change the J1 resident or J1 fellow, their status from J1 to H1B. And they will have to fulfill their J1 waiver obligation all 3 years in exclusively H1B status. So You should know that H-1B is not reserved just for physicians. And this is the definition for an H-1B classifiable position. The job itself has to require a bachelor's degree or higher in a specific field that is directly related to the job offered. So doctors, that's very easy. Medical degree, practicing medicine is obviously perfectly in line with their field of study. But you should know that most H-1Bs are not used by healthcare professionals. In fact, most H-1Bs are used by individuals in the information technology sector. So software engineers, that's a huge one, computer programmers, etc. But within the healthcare sphere, you've got doctors, physical therapists, occupational therapists, physician assistants, nurse practitioners, CRNAs, etc. They can all take advantage of the H-1B program. Now, H-1B is temporary work authorization and status, and you can have a maximum of 6 years in H-1B, and it's granted in as much as 3-year increments. Now, you don't have to apply for 3 years. You can apply for an H-1B and request 6 months if you want, or 1 year, or something less than 3 years. But the downside to doing that is if you anticipate the person is going to be employed with you longer than 6 months or a year, and you've requested only 6 months or a year, then you're going to be refiling for an H-1B earlier. And if you did it every year, your legal expenses for H-1B are going to be exponentially higher. So it makes sense to request H-1B in 3-year increments, unless you know for a fact the person is not going to be employed with you more than, say 1 year or 2 years. So qualifying elements for the H-1B, you have to have a valid employee relationship between the petitioner and the H-1B worker. This is important because, and this is a question that comes up all the time, can I lease my H-1B physician to this other group? And the answer is you probably shouldn't do that. And the reason why is when you lease someone out, you are diluting the employer-employee relationship. And USCIS is looking at not just an agreement or a W-2 or a Form I-9, they're looking at elements of supervision and control. Who is dictating that individual's job duties throughout the day? Who's supervising them? Who has hiring and firing authority? And who is the source of the instrumentalities of their employment, their benefits, things like that? It is helpful if the source of funds, source of compensation comes from the petitioner, but that's not dispositive of the employer-employee relationship. And in fact, USCIS really focuses on supervision and control. So as you can see, if you lease that H-1B physician out to an end client and they're really directing their day-to-day activities, then USCIS is going to take the position that that's not a true employer-employee relationship and the H-1B ought not to be approved. Another concept, and we've been running into this quite a bit recently, is the prevailing wage. When you're applying for an H-1B, you have to affirm that you will be paying that worker, that physician, at least the prevailing wage or greater. So what's the prevailing wage? The prevailing wage is this survey-derived wage level, and there are 4 per position and geographic location. 1 being the kind of the entry level and 4 being the highest, and that might entail extra experience or a director level or managerial duties. But you have to pay that physician at least the prevailing wage. And where we're running into problems is with, for instance, hospitalists. And the prevailing wage right now, there's this default wage that the Department of Labor uses, is $115 an hour, or annualized, that's $239,000, $200 per year. And if your current compensation level for a hospitalist is, say, $230,000, well, you're below the prevailing wage, and you're not going to be able to get an H-1B. So you have a decision to make. You have to either agree to bump up that H-1B physician's salary to $239,200, or not go forward with the H-1B, or try and use alternative wage data and convince the Department of Labor that, hey, yes, you have your prevailing wage, but here's what the market is really saying that we ought to be paying these people. And the caveat is that alternative wage data is not always accepted by the Department of Labor. So you're kind of rolling the dice. And really the path of least resistance is use the Department of Labor's prevailing wage data and promise to pay that amount. I can't overemphasize enough that H-1B is employer and site specific. So if you have an H-1B with Company A, that means you can only work for Company A. And Company A, within their H-1B application, will say they're going to work at worksite A. And you can have multiple work sites in the H-1B, so maybe it's worksite A, B, and C. Those are the only work sites that are approved, and that is the only employer for which that H-1B worker can be employed by. If you're going to make any changes to that H-1B worker's working conditions, including work sites or compensation changes or change of duties, then you should consult with Immigration Counsel, and then they can evaluate and analyze and tell you whether or not an amended petition needs to be filed. And that is a critically important concept. USCIS is a federal entity that will grant permission, but they will not grant forgiveness. So as long as you ask for it up front and get it blessed, then the likelihood is that USCIS will approve that amended petition. But if you go ahead and implement the change, and then go back and say, hey, USCIS, we kind of screwed up and we made this change before we filed an amended petition, and USCIS concludes, well, you should have filed an amended petition, then what happens to your H-1B worker is that they've fallen out of status, they lose their work authorization, and in all likelihood, they're going to have to depart the country and then come back in if possible. So critically important to be aware that any material changes to the working conditions of an H-1B will require the filing of an amended petition before those changes are implemented. Now, practical advice, I would say this to both candidates and employers, but if you're a candidate, then you ought to be transparent about your needs. You should be saying to prospective employers, hey, I need H-1B. There is no upside to hiding that fact. It's going to come out at some point, and if that candidate hides that information and then surprises the employer at the last minute, then the reality is that an employer is going to be mad and potentially pull the offer. On the employer side also, you should be transparent. If you're going to do this, if you're going to leverage H-1B, then you should be transparent that you do entertain H-1B sponsorship. And again, it behooves you to be familiar with the process so that you can answer some of the questions and concerns that might be raised by the candidate as they go through the interview and negotiating process. In my experience, and we're doing this all over the country with healthcare employers, organizations, systems, big and small, really the trend is to leverage the H-1B program. There was a time, probably I would say 10 to 15 years ago, where I was observing some hesitation or recalcitrance in engaging in the H-1B program. But by and large, I'm seeing many of our clients coming to the table and saying, hey, we want to sponsor H-1Bs. And I think that's because they know and they realize that there is this untapped talent pool that they can capitalize on. And candidly, there's some great candidates out there. So some recruitment issue identification. If somebody is already in H-1B status, whether it's because they're doing their training in H-1B or let's say they're post-training and they're in H-1B, then a critical question to ask and to know the answer to is how much H-1B time have they used? Because again, they only get 6 years, generally speaking. And if they have already used 5 years of H-1B time by the time they get to you, then they only have 1 year left. So you have to ask more questions. Hey, are you eligible to extend your H-1B beyond the normal 6-year limit? Have you started the permanent residency process? And if they haven't, and they aren't, then you may want to decide to walk away because you know that, gosh, there's all this extra front end work we have to do to try and make them eligible to extend their H-1B. And candidly, because of processing times, and we'll get to that later with the Department of Labor and USCIS, we don't know if we have enough time to make them eligible to extend their H-1B. So it pays to know that information up front. And if they open the door and they say, hey, I need H-1B sponsorship, then they're opening the door to you asking some of these more specific questions around really the background and how much time they have left. If they're completing a J-1 waiver obligation, so they haven't finished their 3 years, but they want to change employers, and we run across this a lot, then they have to be able to make what's called an extenuating circumstances claim. And extenuating circumstances typically fall into two main buckets. And those buckets are one, kind of financial hardship, facility closing, or there's just not enough of a patient population to support that physician, or the patient population failed to kind of embrace that foreign physician. And then the other bucket is, well, the employer sponsor is kind of engaging in bad conduct and acts, maybe being abusive to the physician, having them work in locations that aren't designated, not paying them the way that they said they were supposed to be paying them, et cetera. So you cannot transfer your H-1B employment and J-1 waiver unless you can successfully claim extenuating circumstances. And those extenuating circumstances have to be beyond the control of the physician. So they can't have anything to do with it. They can't have dirty hands. Okay, then kind of the final analysis as you're evaluating leveraging the H-1B program is, can you claim an exemption from the H-1B cap, or are you subject to the cap? And as background, there's a limit, a numerical limit on the number of new H-1Bs that USCIS will approve, and that's set at 65,000. There's an additional 20,000 for individuals who have a U.S. master's degree or higher, so 85,000 spots. Demand is typically around 200,000 per year, so obviously the demand far outstrips the supply. So USCIS uses a lottery system to determine who's going to get those 65,000 and then those 20,000 spots. If you're an employer, you probably don't want to roll the dice on that process. Plus, it's a little bit cumbersome because you effectively file in April and you can't have your H-1B worker until 6 months later, even if it's selected for processing. October 1 is going to be the earliest that cap subject H-1B worker can work for you. So most of our clients will claim a cap exemption from the H-1B cap. And the way that they do that is USCIS has effectively kind of made the definition of a cap exempt entity a lot easier since January of 2017. So if you are a nonprofit entity and you maintain a formal written affiliation agreement with an institution of higher education under the Higher Education Act, then you may be able to claim an exemption from the H-1B cap. And what that does for you is that it allows you to file the application at any time during the year and allows you to set your start date, request your start date at any time during the year. It doesn't have to be October 1 or after. So knowing that medical residents and fellows typically finish their programs June 30 of each year, you can set that H-1B to be effective July 1. Finally, and I don't know in the state of Texas whether or not you get a lot of Canadian candidates, but if they are Canadian J1s and let's say they're late to the game in the recruitment process, so they've missed the window to file for a Conrad 30 waiver. If they're Canadian and they're subject to the 2-year home residency requirement, there's kind of this end around that only Canadians can take advantage of. Canadians are considered visa exempt. And so they don't have to go to the U.S. Embassy or U.S. Consulate to apply for a visa stamp. So they can have an employer here in the U.S. submit an H-1B application for them and request what's called consular processing, instead of requesting a change of status. As you recall, if you're subject to 212E, you can't change your status from J1 to anything else. So we're not asking you to do that. We're saying, hey, just approve the petition, kind of the merits of the petition, and then we'll deal with this overseas or across the border. But because Canadians are visa exempt, they don't have to apply for an H-1B visa stamp. Again, that's another prohibition. You can't apply for a visa stamp. Well, Canadians don't have to do that. So they just present themselves at the border or the port of entry or at the airport and present their H-1B approval, and then Customs and Border Protection should let them into the US, admit them as H-1Bs, and then they can commence employment. Now, this is a short-term fix. It doesn't get rid of the 2-year home residency requirement, but it might, one, get that doctor to you earlier, so they don't have to wait for the next year's waiver period or waiver application process. You can get them working for you. And then as the next year comes, you can have them submit, or you can submit a J-1 waiver in the following year, hope that that gets approved, and then they start fulfilling their waiver obligation after that. So it's a great tool for Canadian citizens. Now, I've said a lot, and we've covered physicians and J-1 waivers and H-1Bs, and I just want to check very quickly if there are any questions at this point, any comments. Okay. Seeing none, let's move on to nurses. So that's another hot area of immigration right now. All across the country, we all know there's a shortage of registered nurses. And there is a specific carve-out, a specific process for permanent residency for registered nurses, and it's called the Schedule A RN process. Schedule A means that the Department of Labor has taken effectively judicial notice that there's a bona fide shortage of RNs in the US. And because of that, they don't have to go through the labor certification process. That means they don't have to prove to the Department of Labor, the employer doesn't, that there is a shortage via live recruitment. So you don't have to recruit, you don't have to post ads, etc. And the first step is to file an immigrant petition, an I-140 petition with USCIS, and you can file that using premium processing, which means you'll get a decision in about 15 business days or less, and that will establish that nurse's eligibility for a permanent resident visa number. Now, the problem with this strategy now, and it's gotten way more popular over the last couple of years, but that popularity has kind of had a kind of a deleterious effect. There's now a very long line to secure a permanent resident visa number through this process. So what was effective 2 years ago really isn't as effective now. So that's the caveat with recruiting foreign nurses at this point. If you started the process today, then it is entirely possible that they're not going to get their green card for upwards of, I don't know, 2, 3, maybe 4 years. If they're overseas, so you're working with a recruitment agency, for instance, and they're overseas and you start the process today, then you may be waiting on that nurse for a few years before they can step foot in the US and start working for you. And we all know that you have immediate needs. So this process was effective a couple of years ago because there was no line, there was no backlog of visa numbers. But right now there's a pretty significant backlog. And it's really never been an option if your nurse was born in India or in China. Those folks may be waiting decades to get their green card. So as you're evaluating candidates, if somebody is asking for Schedule A sponsorship, or bringing this up as an option, but they were born in India or China, it's really kind of a non-starter. It's not going to work for them. Something you should also know about RNs in the context of H-1B is that USCIS typically has taken the view that RNs cannot be eligible for H-1B. And the reason for that is most employers do not require a BSN for their nurses. And there isn't a state in the country that requires a BSN for RN licensure. So that kind of undermines the argument that the job can be H-1B classifiable. Now, there are certain types of nurses, CRNAs, APNs, NPs, etc., that do qualify for H-1B because it's clear that the degree requirement is a bachelor's degree or higher. And there are certain types of RN positions that USCIS will entertain on a case-by-case basis. If they're so complex that really only someone with a BSN ought to be hired into that position, and the employer can show that that's been their hiring history, then that may be a situation where an H-1B is feasible. This just gives you an idea of the steps that you have to go through for Schedule A, permanent residency processing for a nurse. Again, parts of this process take a long time. The first step being get a prevailing wage determination from the Department of Labor, and that might take 6+ months. There is a posting requirement, but it is not intended to be a recruitment device. And you post the notice. It's really an 8.5 by 11 piece of paper at the worksite location for 10 consecutive business days. And then you observe a 30-day mandatory waiting period after that, and then you can file your I-140 petition. But everything kind of stops there until the person's priority date or their place in line becomes current, so that a permanent resident visa number becomes available to them. What I would say to you, just as practical advice in the context of recruiting nurses, is this. If you're working with a recruitment agency, and there are a lot of agencies that are recruiting out of the Philippines, South America, etc., you can still leverage or take advantage of this program if the recruiting agency kind of has a pool of talent that they've been accumulating. And they have started the permanent residency process for, and they've gotten them a place in line or a priority date. And that priority date is really going to be the date that an I-140 petition is filed for them. So if they've gone through that process and they have a priority date, then they're kind of in the queue. And then once their date comes up, and let's say that the company has been building this talent pool for a couple of years, then the folks that they started out with are probably getting close to the point where their place in line is going to become current. And then they can switch gears. They can have a new petition filed for you, the new employer, but you get to claim or retain their priority date or place in line. So you can take advantage of an existing talent pool. And if you're also taking the long view for yourself and you think, look, yes, we have a shortage now, but we also know that in the future we're going to have a shortage. So let's start building this line of talent. We know it's going to take a while for them to start arriving, but we're going to start building that line and that pool now so that 3-4 years from now, we'll be in great shape. So there isn't a complete disincentive to take a look at this program if, again, you're taking the long view. To the extent possible, the low-hanging fruit in the registered nurse recruitment area are Canadian nurses and Mexican nurses. And the reason for that is, even though the permanent residency process has the same kind of hiccups and hurdles that everyone else does, Canadians and Mexican nurses can enter the United States in TN, trade NAFTA status. And TN is great because you can get it in 3-year increments and you can renew or extend indefinitely. So there is no statutory limit on the number of times that you can enter the US as a TN. And in fact, I know of TNs in the Detroit area who've been working in TN status for 15 to 20 years. At some point, I mean, realistically speaking, Customs and Border Protection might have some questions, might ask, hey, you've been coming in for 15 years. What's the deal? Do you intend to be a permanent resident? And so you'd have to cross that bridge when you get there. But with Canadians, again, they're low-hanging fruit. You can get them in now. You can start the permanent residency process for them. And then they can continue work in the U.S. as in TN status while they're waiting for their place in line to become current. Finally, another great place to recruit is nurses, foreign-born, who are getting their BSN or their associate's degree here in the United States as F1 students. Once they complete their degree program, they're eligible for what's called optional practical training, OPT, and that will give them 1 year of work authorization after they graduate from their diploma program. Now, that's only going to buy them 1 year, and if priority dates don't clear, if they don't get to their place in line within that 1 year period of time, then yes, they're going to have to stop employment and either depart or change their status or take some other action. But your employment relationship will end at that 1 year point in all likelihood. Okay, so that's nurses. And now we're going to pivot back if we have time, and I'm not sure where we are on time. But we'll pivot back to one of the main ways that a physician can pursue permanent residency, and that's perm labor certification. And again, perm labor certification is where the employer has to prove to the Department of Labor that there is a shortage of minimally qualified U.S. workers. And they do that through live recruitment. Physician labor certification is usually pretty easy. We all know, in your own experience, you know that you wouldn't be sponsoring that physician if it were easy to recruit for that type of medical specialty in that location. And so when you do go about posting live ads, there isn't a lot of great danger that you're going to uncover or generate a US candidate. So we rarely, if ever, see problems in the context of physician labor certification. It is a three-step process. The first step is with the Department of Labor. The second step is the second and third steps are with USCIS. Now, this is a bit unprecedented. We're in a weird time in that even physicians who go through the green card process are experiencing a permanent resident visa number backlog. So there is a long line even for physicians. And it's always been true for Indian and Chinese national physicians, but now that's extending to everyone. So even if you're from Canada or the UK or France or really any other country in the world, those physicians as well are experiencing a backlog. So we might not see their priority dates become current for, 2, 3, 4 years. It's important to note that the labor certification permanent residency process is an employer-based, employer-owned process. So candidates can bring this up. They can say, hey, I'd like for you to sponsor me for permanent residency, but you as the employer are not obligated to sponsor them in permanent residency. You make that choice. Now, it may be a negotiating tool, and you may feel, hey, I have to offer this if I'm going to land this recruit. And yeah, that's the reality. That's the practical reality. But understand that when push comes to shove, it's the employer's choice whether or not you're going to do this. This just gives you an idea of current processing times of the first stage. So it may take 20 to 22 months just to get through the first stage. The labor certification application, once it's submitted, it's taking 13 to 14 months to process right now. So it would be prudent at the outset for both the employer contact and the physician who's being sponsored to understand it's going to take a long time. And as we all know, physicians like to be updated. But unfortunately, many of the updates as you go through this process are going to be, hey, nothing is happening. It's still in process. That gets them upset, gets them frustrated. But again, if you level set expectations from the outset, there's just going to be a lot of waiting periods where nothing is happening. And then that may assuage their concerns and their anxiety as you go through the process. Okay. This last process is the Physician National Interest Waiver, and it's great for individuals who are J1 waivers. Many of the requirements are very similar to or the same as a J1 waiver. So, but instead of working in a medically underserved area or a health professional shortage area for 3 years, you're adding 2 more years on. So an aggregate of 5 years in a shortage area. Still have to work full time, providing direct patient care 40 hours a week. And you have to have an employment agreement in place that kind of memorializes that relationship. This process allows you to skip. The waiver is a waiver of the labor certification process, so no testing the job market. And you can submit this petition using premium processing. So again, getting to the point where you've established the eligibility of the physician for permanent resident visa number, pretty quick. Then it just comes down to waiting for your priority date. So the unfortunate thing is PNW does not get you any faster to a priority date. So you'll still be waiting in line until the number becomes available to you. I just wanted to provide this slide, and you'll get a copy of this after the presentation. This is an example of the visa bulletin, and this is published every month by the Department of State. and it gives you the priority dates, the places in line for the two main countries here that are important to us, China and India. And then everybody else is in this category, the all chargeability areas except those listed. So that's going to be Canada, UK, France, Japan, Korea, etc., Pakistan. So what I'll leave you with is that this process can cause anxiety, obviously, for the candidates, and as well as the individuals who are on the front lines for the employer negotiating these deals. You're going to find that physician candidates are going to have kind of this varying levels of education and knowledge around the immigration process. The ones that know just enough to be dangerous, they're going to be dangerous, and those are the ones that are going to be a little bit of a handful for you. But it would behoove you, and it will pay dividends for you to kind of become familiar with these processes, so that you can kind of issue spot and identify concerns from the outset, maybe even answer and screen some questions initially, and then take information and facts to your immigration counsel so that they can analyze and advise, hey, what are next steps? Retention, in my experience, and what we're seeing across the board is a significant issue. A lot of sponsored physicians, they've developed this reputation that, hey, they're using their sponsor to get a green card, and then they'll leave them. Or they're using their sponsor to get a J1 waiver, and then they're going to leave them as soon as they finish their 3-year waiver obligation. And unfortunately, it's true. By and large, that happens quite a bit, and there's really nothing you can do about it. Not a lot you can do from the outset to kind of screen for that. So you should understand and maybe go into this process with the knowledge that, look, at worst, we're going to get 3 years out of this person. And maybe in 3 years, we're going to have to go back through this process and go through the J1 waiver again. But if you have a good retention program, what I've observed is, engendering loyalty, making sure that physician feels like he is valued and needed. That can go a long way towards them extending their stay beyond the first 3 years. Finally, I would recommend that if you do jump into the immigration process, then make sure that you engage good immigration counsel who is familiar with healthcare immigration, physician immigration, J1 waivers. That is going to pay huge dividends as they take you through the process. And with that, I will be happy to take any questions if we have time. If there are no questions, then I will thank you for your attention and for the opportunity again to have this conversation with you.
Thank you, Michael. That's great information, and we always appreciate when you provide your expertise here to the healthcare employees in North Texas. Thank you. I have a question for you.
Sure.
Can an employer submit more than one J1 waiver application in a single year?
Yeah, great question, Chris. The answer is yes. Depending on the program and depending on the number of additional applications you might submit. And those are going to be evaluated on a case-by-case basis. But the caveat here is, even though, for instance, the state of Texas or HHS would entertain more than one application from the same employer, even the same work site, you have to understand that those applications are going to be competing against each other. So the question is raised, what do you tell candidate 1 versus candidate 2? If they ask, do you have any other applications that are being filed this year? You have to answer yes. They're going to have the same question. Well, are you going to give mine priority, or are you going to give that guy's priority? So just be advised that they will be competing against each other.
What obligations does an employer have if they terminate an H-1B physician?
Okay, yeah, we see this quite a bit. If you terminate an H-1B employee early, then a little known and sometimes little practiced requirement is that employer must pay the reasonable transportation costs of the H-1B worker to get back to their home country. Now, that doesn't mean first class ticket or a charter jet. It just means coach class airfare. And the obligation is that you actually pay for it, or you give them the ticket. And what we recommend is, when you bring this up to the H-1B worker, you make them acknowledge and either accept or decline that plane ticket in writing. And that way you've kind of covered your bases and created a defensible argument, even if they refuse to accept the payment.
Great.
As
Thank you,
well, you
Michael.
need to notify USCIS that they are going to be their employment will be terminated.
Okay. Thank you, Michael. That's all the questions that we have, and I wanted to thank you for being here today and providing this presentation, and to thank all of the attendees. Michael, you have any closing comments?
No, obviously, we greatly appreciate the opportunity, and we hope you all have a great day.
Thank you, Michael, and thank you for everyone for attending. We're now going to end the webinar. Thank you.
Thank you. Bye-bye.
Bye.